The Bogosity Podcast, early and ad-free. Become a subscriber at Patreon, Subscribestar, or Discord. Use the links at donate.bogosity.tv.
Welcome to the Bogosity Podcast for the week of October 27, 2024. The podcast that makes organic pianos. This is your host, Shane Killian. Let's deputize the news of the bogus. We covered the corruption of the secretaries of state and judges trying to remove Donald Trump from the ballot. We've also wondered how that's any different from the corruption of removing libertarians from the ballot, but anyway. In Colorado, Trump was kicked off the ballot by Colorado Supreme Court Chief Justice Monica Marquez in a decision that was reversed unanimously by the Supreme Court. The way it works for Colorado is judges are voted into 10-year terms, and then voters get to vote straight yes or no on them. Marquez is on the ballot this year. So the Article 3 project is actively campaigning to remove Marquez, beginning with an ad that sounds like this.
Colorado Chief Justice Monica Marquez tried to take Trump off the Colorado ballot, illegally. She wanted to disenfranchise over 550,000 Trump primary voters. This was so outrageous the Supreme Court stepped in, a 9-0 decision. Even the 3 left-wing justices reversed her. Marquez doesn't respect Colorado voters. She doesn't respect democracy. It's time to fire her. Vote no on retaining Monica Marquez on November 5th.
A group of left-wing voters went to the court saying Trump should be removed from the ballot because he committed an insurrection, a charge he was never convicted or even arrested for. When the lower court ruled against them, they went to the Colorado Supreme Court, which overturned it 4-3. In addition to Marquez, the others were Richard Gabriel, Melissa Hart, and William Hood. Of those 4, only Marquez is on the November ballot. Davis wrote a commentary that was published in the Denver Post, quote, "Not one rioter has been charged with a violation of the insurrection statute, 18 U.S.C. section 2383. Even Jack Smith, the highly partisan and controversial attorney assigned by Attorney General Merrick Garland to prosecute Trump, has not levied that charge. Those 4 justices did not defend democracy. They defiled it. They used a Civil War-era provision intended to bar members of the Confederacy from serving in government to remove a candidate from the ballot who had engaged in protected speech. They used the kangaroo court of the January 6th Select Committee as a substantial basis for their decision. These justices arrogantly took it upon themselves to decide that they, and not Colorado voters, would choose the winner of Colorado's electoral votes." In addition to Marquez, Maria Birkenkotter and Brian Boatwright are also on the ballot, 2 of the 3 that voted against throwing Trump off the ballot. Davis called for them to keep their seats, quote, "They are also appointees of Democrat governors, but these 2 justices, unlike Marquez, respected the right of Colorado voters to vote for the candidate of their choice. Birkenkotter and Boatwright each wrote powerful dissents against the majority's opinion. Regardless of their views of Trump, Colorado voters need to send a message to Marquez that her attempt to disenfranchise over 550,000 of them was repugnant to the fundamental values of the Republic." It'll be interesting to see what happens, and if Coloradans remove her from the ballot, who will be replacing her, which will let us know if the message was heard.
Sometimes you just have to stomp some skulls. From the mind of Mr. Dapperton, a game for the ages. In a world where a race of undead furries tries to take over the world's nuclear arsenal, one man must stop them. But which man? You choose. Dapperton. Elon.
Not my Dogecoins.
Joe.
Build me back.
Shapiro.
My kippa's ruined.
Or Don John.
Ow, my ear.
Forget those losers. You know you want to play as me, Lord Killian. That's right, you can stomp the skulls of those commie furries and save the universe as me!
7 complete different worlds with more coming all the time. Full controller support. You can even get eaten by a worm and pooped out into a furry cathedral. You know you want this game. Go to links.bogosity.tv/skullstompers and play Skull Stompers now.
Going way back years on my YouTube channel, I said in videos such as how to fix healthcare without spending a dime and how to argue for universal healthcare that one big problem in most states in the U.S. was certificate of need requirements. Basically, if you want to open a hospital, you have to get a statement of need from other hospitals in the area saying there's a need for an additional one. In other words, you have to get permission from the very people you would be competing with. Basic economics. If you restrict the supply, the price goes up as more people in need try and grab fewer resources, in this case patients needing care. That's bad. But if you increase the supply, in other words, build more hospitals, price goes down. Certificate of need laws make healthcare more expensive and make resources more scarce, needlessly increasing wait times. If you've ever had to make a separate appointment at a hospital just so your doctor can give you an injection or a few stitches or something simple like that, and you think, why couldn't he just do that in his own clinic? Then in all probability, certificate of need laws are the culprit. Now, in North Carolina at least, those might be a thing of the past. The North Carolina Supreme Court has ruled unanimously that they will hear the issue as to whether or not these laws are unconstitutional. Politicians on both sides of the aisle keep saying these are necessary regulations of the healthcare industry, because if we had more hospitals, then the bad thing that would happen is... Actually, I don't even know. They seem to not ever tell us that part. One recent argument is that building hospitals is expensive and that would be passed on to patients in higher bills. The North Carolina Healthcare Association said in its 2024 legislative brief, quote, "The law ensures access to health care for medically underserved populations and prevents oversupply that can lead to higher health care costs for patients." We just covered why that's laughably ignorant. There has recently been increasing public concern over these, basically as soon as people become aware of them, saying that these stifle competition, raise prices, and give the government too much control over our health care. Several North Carolina lawmakers have been elected in part over this issue. But the hospitals have big, powerful lobbies, and they have constantly worked to keep these requirements in place. So, in this case, Dr. Jay Singleton, an eye surgeon in New Bern, says these laws stifle the constitutional rights of him and his patients by requiring that he perform eye surgeries at an established hospital instead of his own facility. There wasn't anything wrong with his facility. It wasn't inadequate or unsanitary or unsafe or anything. It was solely because he hadn't secured a government-issued certificate of need. As a result, he's had to do most of his surgeries at Carolina East Medical Center at a significantly higher cost to his patients. He says he could perform cataract surgery for $1,800, but the local hospital charges $6,000. He's not even allowed to buy the necessary equipment to do them in his office due to the rulings made against him in his attempt to get a certificate of need. Only the local hospital is allowed to have the equipment. In their unanimous per curiam opinion, the North Carolina Supreme Court ruled. Here, plaintiff's complaint alleges facts that could undermine the certificate of need law's constitutionality far beyond the particular circumstances of those plaintiffs. Indeed, in their supplemental briefing, plaintiffs acknowledge that, should they prevail, the need for relief that extends beyond plaintiffs will likely arise here and will likely entail facial relief. We agree. The complaint contains allegations that, if proven, could render the certificate of need law unconstitutional in all its applications. They vacated the existing decision and remanded it back to the trial court to come up with a much broader ruling that will address the constitutionality of certificate of need laws statewide. This is just one more indication of how the people who claim that supply and demand doesn't work with healthcare for some reason are either laughably insane or bewilderingly corrupt. Every time it's been studied, certificate of need laws have been found to limit healthcare and raise costs, just as basic economics says they would. Hopefully, it won't be too long before this mockery is put to rest once and for all.
If you're on the Wi-Fi in a coffee shop or hotel, anyone on that network can get your traffic. Do you really trust all of those strangers? For that matter, do you really trust your ISP? A VPN can protect you from prying eyes, disguise your location, and even foil government censors. It's essential in this day and age, so go to vpn.bogosity.tv and you'll be taken to BoxPN. Starting at just $2.99 a month, you can get unlimited high-speed connections to VPN servers all over the world, and they don't log connections, so your privacy is assured. Traveling abroad, just VPN home, and don't worry about what those other governments are doing. Back at home, stop your ISP from traffic shaping and messing with the quality internet access you're paying good money for. You can connect from multiple machines at once, including your smartphone or tablet, and it supports all the secure standards, including OpenVPN and SSTP. Bypass censors and surveillance with your own secure VPN connection. Go to vpn.bogosity.tv.
Here's a kid I can sympathize with. I got in trouble for school for doing assignments on my computer because you just push a button and the computer does everything for you. Even though programming my Commodore VIC-20 to do algebra taught me more about it than just doing the homework would. Same with art. Whether it was programmatic art or digital painting or 3D rendering, I always heard the same thing. And believe it or not, I even heard it with writing papers on my Commodore 64's word processor. How do we know the computer didn't just write it itself? Admittedly, that part's a little more possible today, but again, AI just doesn't work the way people think it does. And although it would be bad to just tell ChatGPT to write your paper for you, here we have a case where a school punished a kid for even using AI as a research tool. As I've said many times and will always say, AI is not a hotline to truth, so don't take its word for anything. But that doesn't make it useless. It can help, and in fact can be a tremendous help to anyone who knows how to properly use it. And like my algebra homework back in the 80s, learning to properly use AI as an assistant can teach you more about the subject than you could learn traditionally in the same amount of time. Hingham High School in Hingham, Massachusetts, punished a student for cheating when he used AI to assist him in writing a paper. His parents, Jennifer and Dale Harris, have sued the school, saying they falsely accused him of cheating. They punished him with detention, and his grades suffered as a result. That resulted in him not being allowed into the National Honor Society and adversely affects his chances of getting into his top school choices. Jennifer said, quote, "He got a perfect score on the ACTs, and he's looking to go to Stanford or MIT or some of the top schools. He's missed the opportunity already for rolling admissions." They're asking the court to call for the school to, quote, "exclude any zero grade from grade calculations for the subject assignment, and to, quote, immediately repair, restore, and recertify plaintiff student's letter grade in social studies to a grade of B." They also demanded he be retroactively appointed and immediately inducted into the National Honor Society. For some reason, the school decided to make everything worse for themselves in court when they said in their filing that the student, quote, received relatively lenient and measured discipline for a serious infraction, unauthorized use of artificial intelligence on a project, and, equally important, failing to cite his use of AI. In short, he cheated himself and other students, and he plagiarized. Funny how they know what he would or wouldn't have cited since they didn't even allow him to finish the paper. Another point that I hope the courts didn't miss is that how could failing to cite be a problem for something they supposedly prohibited entirely? One big problem is the rule the school accuses him of violating doesn't exist. The school's handbook defines plagiarism as, quote, unauthorized use or close imitation of the language and thoughts of another author, including artificial intelligence and the representation of such as one's own work. But that doesn't exclude using AI for research purposes. The section they cited bans, quote, unauthorized use of technology during an assignment, which was made to stop things like calculators for math assignments, and, quote, unauthorized use or close imitation of the language and thoughts of another author and the representation of them as one's own work, which shows an astounding ignorance of how AI works. By the way, 7 other students disciplined for academic dishonesty had been inducted into the National Honor Society, including one censured for using AI. That didn't help them either. So they're also demanding that the school put in place an AI policy that isn't completely floofy, one that's easy enough for even school teachers to understand and that can clearly be articulated to the students and applied when needed. They also want administrators to, quote, undergo training in the use and implementation of artificial intelligence in the classroom, schools, and educational environment by a duly qualified third party not employed by the district. The court is still considering it. Hopefully sane heads will prevail. Of course, judges have never been ones to understand technology either, especially if whichever politician nominated them is one of the ones engaging in AI hysteria.
Do you have children, or nieces or nephews? Are you homeschooling, or just want to counter some of the socialist indoctrination most children get in school? If so, go to bogosity.tv/TuttleTwins, and you'll be taken to a website where you can get some great books for elementary-age children. The Tuttle Twins books are books about liberty and free market economics that include children's versions of Bastiat's The Law, Leonard Read's I, Pencil, and Hayek's The Road to Serfdom, as well as books about the Federal Reserve and how regulations protect business cronies. They'll learn about the harm caused by eminent domain, or regulations passed in the name of safety, and fundamental concepts of liberty. And as you can see from the sample pages on the website, they're all easy to read and nicely illustrated. They're just $9.99 a piece, or get a special discount as well as free bonuses when you purchase all 5. You can even buy in bulk to donate to schools and local libraries. So get the Tuttle Twins books at bogosity.tv/TuttleTwins.
And now it's time to formularize this week's biggest bogon emitter. And this week it goes to the Connecticut Attorney General, and I cannot believe that this is something that politicians still don't get after Bruen. They're claiming that hunting rifles are not covered by the Second Amendment. Arguing in front of the Second Circuit Court of Appeals, State Attorney Joshua Perry said that the Second Amendment only applies to guns commonly used in self-defense, and that semi-automatic hunting rifles don't apply. A federal judge inexplicably ruled against the National Association for Gun Rights, who were challenging the state's 2013 assault weapons ban. District Judge Janet Bond Arterton spent 74 pages trying to show that the Supreme Court didn't actually mean what they said in Bruen. In fact, she claimed that Bruen somehow only applied to handguns. So the NAGR has appealed to the Second Circuit. And now Connecticut Attorney General William Tong still has his people making ridiculous arguments he hopes the judges are stupid or corrupt enough to accept. Listen to Perry yourself.
So Connecticut restricts instrumentalities that are unusually dangerous, that are like M16 rifles, that have combat functional features, that allow users to hose down, as one of our declarants put it, a battlefield or, tragically, a school and cause a disproportionate number of casualties. Those are the pistol grips. Those are the muzzle shrouds. Those are the forward grips that give a shooter the leverage, the aim, the capacity to take too many lives, as the shooters did at Sandy Hook, in too little time. So Connecticut has calibrated its restrictions precisely to the constitutional contours by ensuring that we restrict weapons only that are unusually dangerous and only the ones that are like the M16 rifles. And what Heller and Bruen both point out is that the plain text of the Second Amendment, as historically understood, protects a right to self-defense, not a right to possess any type of weapon for any sort of confrontation, but instead going back to the English Bill of Rights of 1689, going back to Blackstone.
Immediately after that, in oral arguments for Grant v. Ravella, Perry was at it again.
So I think it's important to note that Connecticut has not banned hunting rifles. Those are, whether or not they're constitutionally protected, they're certainly democratically protected. As a rule, something that's popular doesn't need constitutional protection because it's popular. And hunting rifles certainly would fall into that category. As to whether Connecticut could restrict hunting rifles, I think we probably could not restrict hunting rifles because I think it could be shown that they are not unusually dangerous. They're not disproportionate and ill-suited in the way that, for instance, the Fourth Circuit found that AR-15s are. And the record might well show that they were used and useful for self-defense. I'll be honest that we haven't done that analysis, but I have no reason to think that that wouldn't be true.
So they don't ban them because they just won't ban them, not because they can't under the Second Amendment. And he even said that his point was that the Constitution doesn't protect anything commonly used for any lawful purpose.
Bruen doesn't talk about ownership, it talks about use for self-defense. And all the evidence in the record suggests that the use of these assault weapons for self-defense is vanishingly rare.
Yeah, well, it's even more rare that they're used to commit mass shootings. Your reminder that over 75% of mass shootings involve handguns, with only 25% involving assault rifles. And rifles of all kinds only represent 3% of gun deaths. In fact, more people are killed with hands and feet than with rifles. The Second Circuit's Chief Judge, Deborah Ann Livingston, sounded like she wasn't having it.
Brandishing, and I'm sorry, that part of the record set me back a little bit, because it seems to me use for self-defense has to be broader than brandishing or actually using a weapon. I mean, most police officers never discharge a weapon outside the firing range over their whole career, but they are using the weapon for assisting others, self-defense and other defense throughout that career. So that statistic didn't seem helpful. Am I missing something about that?
So I think the textual point, Chief Judge Livingston, is that use has to mean something different than ownership. Otherwise, words have no meaning, and the Supreme Court spoke in vain here.
Yeah, so the reason why you have something doesn't matter if you never actually have occasion to use it for that purpose. And you could use that argument to deny any constitutional right you wanted. According to Heller, a weapon can be banned if it's dangerous and unusual. That makes no goddamn sense Second Amendment-wise, but even at that, the AG's office seems to want to rewrite that as dangerous or unusual, which they have to do since the AR-15 is the most common rifle in the United States. Cameron Atkinson argued, the Supreme Court has clearly required Connecticut to show that AR-15s are dangerous and unusual weapons. Connecticut cannot satisfy that requirement because the AR-15 is more popular than the Ford F-150 pickup truck. Instead of acknowledging that their law is unconstitutional, Connecticut is asking the Second Circuit to adopt a vague test that defies the Supreme Court and will allow them to ban all guns based on hysteria about how dangerous they are. Barry Arrington, who represented NAGR, said, quote, "The fact of the matter is that this is political grandstanding by the Connecticut legislature. It has no effect on crime. For obvious reasons, a criminal is not going to walk down the street with the AR-15. All the cases say that handguns are preferred by shooters, even in mass shootings. If the most popular rifle in America is not protected by the Constitution, then no rifle is." As he said in his arguments,
and so the state is saying that millions and millions of people can be disarmed of this particular weapon. As a matter of fact, the most popular weapon in America, the AR-15, because literally a handful, a couple of dozen, have misused them, that this is not the law.
It really sounded like Perry wasn't getting anywhere with Chief Judge Livingston or Judge Allison Nathan, especially if they're smart enough to put his arguments in the two separate cases together and see how it all morphed as he needed to. I swear, when all of these anti-Bruen cases we've covered go back up to the Supreme Court to be knocked down again, their decision should start with the words, "Did we stutter?" So all of that makes the Connecticut Attorney General this week's biggest bogon emitter.
I want to tell you about the eyeglasses I've been wearing for years. As people can see on my videos, I have a very strong prescription, which makes glasses more expensive, especially when I need computer glasses, reading glasses, prescription sunglasses, and most expensively, progressive lenses for general everyday wear. To save money while still getting quality glasses, I get them from Firmoo. In fact, I just got a pair of progressives with high-index aspherical lenses and a nice pair of frames my wife loves for just over $100. It would have been $500 to get them through my eye doctor. Not only do they look good, the glasses are durable. I've worn many pairs for several years without problems. All orders come with a 30-day return policy, a 3-month warranty, and one-on-one customer service. Go to Firmoo, that's FIRMOO.Bogosity.tv anytime you need quality glasses at a low price. Once again, that's Firmoo.Bogosity.tv.
And now let's transcendentalize this week's
Idiot Extraordinaire.
We know you should keep guns away from children. It seems also you should keep guns away from lefties. Case in point, Lucas Kunce, who's running against Josh Hawley for senator from Missouri. Not sure how it's pronounced, but I'm pronouncing it Kunce to rhyme with dunce. He went out with Adam Kinzinger and a journalism crew to show how big and manly he was with guns, and ended up wounding KSHB reporter Ryan Gamboa. And then, for some reason, thought it'd be a good idea to brag about it on X and post the pictures. The first picture of Kinzinger taking aim at a metal target is bad enough, even though he followed it up with pictures of the wounded reporter. It's like one of those puzzles in the funny papers. There are 7 things wrong with this picture. Can you find them all? Starting out with no hearing protection. Sean Davis of The Federalist pointed out just a few of the problems with it, starting with the distance to the metal targets. Quote, "They are shooting steel at 5 to 7 yards with rifles, which could have killed somebody given the force with which the bullets will ricochet off the steel targets at that distance. You would instantly get permanently banned at my range if you did that. 0 questions asked." The International Defensive Pistol Association recommends a minimum distance of 25 yards when firing a 5.56 NATO at a metal target. But for safety, most ranges double that to at least 50 yards. The Scholastic Shooting Sports Foundation recommends a minimum of 100 yards for all centerfire rifles. Davis also attacked Kinzinger for how he posed in the first photo, ready to fire the gun. Quote, "Kinzinger holds his rifle like a complete ninny, and that will never not be funny to me." And pro tip for Adam Kinzinger, the eye protection works better when it's on your eyes, not your head. You stupid idiot. Try using your brain for once. You're lucky you still have one after today. But maybe he did have an issue with his eyes because, quote, "Kinzinger is for some reason using a high-powered scope, at least a 3 to 9x by the looks of it, to shoot a target 5 yards away. There is a bolt-action rifle on the table, so presumably someone was also using that to shoot steel at 5 yards. Insane." He didn't mention it, but the way Kinzinger was holding the forward vertical grip is really weird too, with his thumb up instead of, actually gripping it. Has this military officer never held a gun before? And, you might think that some of this might be understandable for a novice, even though they absolutely should have had an expert there to set up and supervise everything. But I think even the most ranked neophyte would know better than this next one. Quote, "There are at least 2 canisters of explosive tannerite powder on the table, downrange from where guns are being fired. That could have potentially killed or seriously injured someone if someone shot it, or if someone was stupid enough to be shooting close enough to steal for a ricochet to hit it. They're actually pretty lucky only the reporter was injured because, quote, at one point the cameraman is downrange from all the guns, which, given the violations we've found so far, we can assume are not safe and unloaded. Way to think that one through, dummy. And yet, Cunts the Dunce posted all of this with pictures saying, quote, great day at the range today with my friend Adam Kinzinger. We got to hang out with some union workers while exercising our freedom. Always have your first aid kit handy. Shrapnel can always fly when you hit a target like today, and you've got to be ready to go. We had 4 first aid kits, so we were able to take care of the situation, and I'm glad Ryan is okay and was able to continue reporting. You know, the fact that Kuntz was a lieutenant colonel in the Marines and Kinzinger was a lieutenant colonel in the Air Force only debunks the idiotic claim of gun control nuts that only the military and police have the training and discipline to handle guns. Sheesh. Gamboa was injured when Kuntz fired a shot at the metal target that fragmented and ricocheted into his right arm. Kuntz wrapped his arm in a completely idiotic way and for some reason put his belt around it like a tourniquet in the wrong position. Fortunately, someone else came along and did a better job. Attorney and law enforcement analyst Phil Holloway said, quote, why did you put a tourniquet on a grazing flesh wound? Why are people wearing their eye protection on top of their head? Why are you firing 223 rounds at metal targets 20 feet away? Josh Hawley started having a field day with tweets such as, I condemn all acts of violence against reporters and call on Kuntz never to shoot another one. Release the footage. I know the Kuntz campaign needed a shot in the arm, but this is taking it a little far. Remember, guns don't shoot people, Lucas Kuntz shoots people. He also posted a picture of his grandmother with a gun and said that she was better with a rifle than Kuntz. But he did uncover one interesting piece of information if you're curious about what kind of wonderkind set up this operation, quote. So Kuntz's stunt at the fake gun range where he shot the reporter was organized by a criminal who is not supposed to have access to firearms? What is going on here? He posted a screenshot of a story from the Kansas City Star which read, as Kuntz and Kinzinger were shooting, Chad Everett Downs remained nearby. Before the event, Downs spoke with a Star photojournalist, saying that the range was his, but the event was taking place at his neighbor's residence. Missouri court records show that Downs was charged with 17 counts of felony perjury in August by Ray County prosecutor Camille Johnston. His ex-wife, in a court of filing earlier this month, alleged the man owns or has access to guns in violation of his bond conditions. Wow. Just wow. On the plus side, it's nice to know that they actually prosecute perjury sometimes. Speaking of prosecuting, yes, this event is now under investigation by authorities. It was opened by the Clinton County Sheriff after the Daily Wire notified him that Kuntz may have violated the law by failing to report it, which is required with all shootings where an injury has taken place. Hawley tweeted, serious question. Missouri law requires any person who causes injury with a firearm to file a report with law enforcement immediately. Did Lucas Kuntz do that? Failure to do so is a crime. If you wonder what possible response they could have to all of this, here's Adam Kinzinger's on X. Quote, Josh is such a dork. Well, he's not the one who shot a reporter. Quote, what about the police on Jan 6? Condemn those acts of violence? You know he did, so shut up. Quote, also, the reporter is fine and it was a fragment. Guess you don't know how that all works. Wow. Look, this could have been a lot worse. The reporter could have had nerve damage or an infection. If he'd been hit in a vital area, he could have suffered from blindness, concussion, brain damage, or even have been killed. Moreover, shrapnel means the bullet was in multiple pieces, which means that multiple people could have been severely injured or killed. This is a serious thing, and so easily preventable. Do he and cunts actually think it's a common thing for people to go to the range and get hit with bullet fragments? And remember, they had tannerite on the table. If the shrapnel had hit the tannerite, it could have set it off, and who knows what could have happened. Funny how Kitzinger shut off replies to that post. How brave. Or, as Davis said, quote, absolutely mind-blowing insanity from a candidate for a political party that wants to take away your guns because it claims you can't safely own them. To go through all that and still be bragging about your great day at the range? That just has to make Lucas Kuntz this week's
Idiot Extraordinaire.
Well, that wraps up this Shush, You Just Hold the Gun Steady, Don't Tax Your Mind edition of the Bogosity Podcast. I hope you enjoyed it. If you did, please go to donate.bogosity.tv for several ways to support and discord.bogosity.tv to join the discussion. Subscribe at the Discord or at Patreon or Subscribestar, and you can listen early and ad-free. Thank you for listening. Until next time, here's a quote from Dusan Shaystich. Not everyone in this country is a thief or corrupt. If I was, I would be a politician and be doing far better in life. The Bogosity Podcast is licensed under Creative Commons Attribution, Non-Commercial, No Derivatives 4.0 International License.
Bogosity.